Hi, today is the 4th of March. It's about 6 p.m. So, this is the fifth law video. So, I'll cover contract law. The first part of contract law, and basically the most important, or you can say the not the most important, but the fundamental one, is contract formation. When do you have a contract? Before you even try to sue, you have to prove that if the other party says there's no contract, then you cannot claim anything. So in Malaysia, we codify the UK law when we gain independence under the Contracts Act 1950 and the Specific Relief Act 1950. If there is no provision in the Act, then the courts will refer to the UK common law, which is judge-made law. So what is there are three main elements to a contract. There must be an offer and acceptance, there must be intention to create legal relations, and there must be consideration. So what is an offer? So an offer is puts the offerer at a risk, because the moment the acceptor accepts, there is a contract. So it cannot be an offer is normally contrast with an invitation to treat. So if you see an advertisement, that is an invitation to treat in general, and you cannot go to the seller and say you must sell me, because seller might not have stock, seller might have changed his mind. So invitation to treat is more like he's proposing to enter into a contract. And when you buy things online, that is an invitation to treat, and when you pay the money, is an offer, and when the website sends you a message saying payment has been received, that is an acceptance. So an offer can be revocated before the acceptor makes an acceptance, and it has to be communicated also. So in business, we have something called a quotation. That is not an offer, that is only an invitation to treat. When you send the purchase order, and there will be a offer, then the other party has to reply that he accepts. So we have something called the last shot rule in the battle of the forms. So a lot of businesses, they will tell, the quotation will say these are the terms of the quotation, but when the person send the purchase order, they will send their terms together, and it will be different. So sometimes the seller, when he accepts, he will not be accepting his terms. The seller will be accepting the purchase order, the terms on the purchase order. Okay, so the person who sends the last terms, and the other party, if accept, too bad, you have to accept all the terms. So there is there must be offer and acceptance must be certain. You cannot say that in general there must be the agreement must be finalized, not subject to further agreements. There will be one more step. So for example, if I negotiate with somebody for services, like I go to a lawyer, a doctor, I agree, okay, but there are important terms, like a contractor to do something, the important terms, they are not yet agreed to. There are material terms they are not yet agreed to. That will mean that there is no offer and acceptance, because it so-called mean or proof that the parties are not committed to be bound. But if the seller has already done work, let's say the contractor already started your work, you have to give him a restitutionary claim. Restore is under equity, unjust enrichment, where you have to pay the seller for his costs that he has incurred his time. But if the seller, you didn't ask the seller to do it, and the seller go and do it, then there is no need to pay him. And sometimes the contracts are vague. you can have wordings that are not clear, but the courts won't say that there is no contract. Sometimes the courts will try to resolve it by looking at business practice. Okay, so sometimes they will look, let's say businessmen, they like to negotiate, they like to agree, but without in all the details. They don't want to tell you all the details, but they'll look at your previous dealings. If let's say every time you buy from the seller you perform this kind of practice, then that can show lah that you agree to your previous dealings. They can look at your customs, what other people do in the industry, right? And agreements to negotiate in good faith. Sometimes you submit proposals for a design, or you submit tenders. There is an agreement to negotiate in good faith, but sometimes the buyer is not interested to engage you. He just wants to look at your design, so you incur a lot of costs to design all this. Can you sue? Basically, you can sue, but your damages will be very little because you don't know what is the percentage that you could get the contract. But the court will try to calculate a loss of chance, or maybe 5%, 10% chance you may get a contract. So it will be a percentage. Okay. This is of course there are other things that you are studying in a textbook, right? Like when is your time of acceptance? When you send email, is it when you send or when the person receives your email, right? So email is instantaneous, so it's the time you send lah. It's considered when you send, the other person has received lah. Okay, if the person never read, then his email, then too bad lah. Okay. Yeah, but this only apply for businesses lah. So in the next one is ITCLR. We have it must be what the parties intend to be bound by the terms. Okay, it must be, it's just appearance of intention, not the actual intention. Your parties cannot argue that they didn't intend to be bound, they didn't intend to create a contract. It must be what the appearance from a third party observer will appear your words that you use, right? So then intention to create legal relations cannot be subject to contract clause. So sometimes they will agree to do something but subject to contract, that one cannot, right? But unless the other party encourage, the other party say, I will not come out from this contract, even though there's a subject to contract clause, we will still go ahead, and then you incur a lot of costs. Yeah, that can. So going back to the offer and acceptance, so sometimes like when I send my pet to the vet, the vet say your pet is sick, you need antibiotics. So okay, I agree antibiotics, but the price was not was not agreed. Later the bill comes super high, so you can say there is no contract, I never agree to it, right? But of course you have to pay a reasonable price now if you go to court, because a benefit has been given to you. The other guy has incurred costs, like under restitutionary. And sometimes you sign contracts verbally, but you agree on the price, but all the other things is not agreed to, right? There is no contract lah, okay, for important things. Normally in Malaysia we need verbal, because verbal we cannot agree to all the terms, right? Normally there are a lot, like you go to lawyers, you engage a lawyer, architect, engineer, professionals lah. I mean, there are a lot of terms and conditions you will sign on the thing, but sometimes we agree the price, then we pay, but we never go and sign. Is there a contract? In my opinion is there is no contract, because material terms have not been agreed to. Yeah. So it's merely subject to further contract. I think my belief is the practice in Malaysia is like this, okay? Because you need today's world, if I don't sign a contract, do I intend to be bound by it? No, right? Everything needs to be must have terms and conditions, right? So but there is a presumption that in social there is no agreement for intention. So if I agree, tell my neighbor I'll mow his lawn, there is no intention rebuttable, it can be rebuttable. But in business there will be. So ex gratia payment, so that business will say they will pay the employee if you retire early, will pay you ex gratia. So that can be intention to create legal relations, even though it's called ex gratia, grace means because it is in a business context. So the last one is consideration. So consideration, there must be the courts, okay, because contract law exists to promote commercial activity. There must be people want to buy and sell. Unless we have a socialist government like China's communist country, right, where everything belongs to the government, government will take all your things that you produce and they will give it to other people, right? That one you don't need contract law. But in if you believe in private property, right, then yeah, in a democratic country in a democratic system, then we want to separate, we want to get control commercial activity. So but we also don't want promises like husband promise wife, certain things, all this they don't want, unless it is in a writing and it is chopped and stamped by the office registered. So consideration is defined by right and interest from benefited one party and the other party incur a loss. But sometimes one party incur benefit, the other party got no loss, or one party incur loss, the other party no benefit. Is that still consideration? Yeah. In general, you have to look at the case law. Okay. So in Malaysia, we have something called, we allow past consideration. So if you work for a company and then later the company say I agree to pay you money for what you did last year, that is enforceable. That is considered good consideration. But UK is, in the general rule, is no, under the Fox and Beer, the case of Fox and Beer. And if your consideration so even if you pay early, you pay lesser, right? In UK, I agree to accept, let's say somebody owe you 1 million, you say I agree to get 500,000 and then the rest I'll forgive your debt. UK say that one is no consideration, but Malaysia, of course, they accept. Okay. Of course there is So the difficult part comes when you have a modification of the contract. This is a lot of exam now when the student will study. Is when, let's say you got a contractor comes to you and say I cannot complete by the due date unless you pay me more. Right? So there is, under the case of stealing and marriage, there is no consideration for when the sailors have to do the work. Few sailors left the boat, then they have to do more work. They say this is not consideration because you are bound to do it anyway. But in the other case of shipping also, Hartley and Ponsonby, there is, okay. So yeah, sometimes there could be. So Williams and Roffey brothers changes, it overrules stealing and marriage because it changes what is considered as a fresh consideration. So a practical benefit. So a contractor who avoids penalty, right? When you complete the project on time, he doesn't have to pay penalty. That is a benefit to him, right? So it can be a fresh consideration, but there must not be any economic duress. So if you threaten, you tell the other party, I cannot perform your contract unless you pay me more, it will duress it costs, they are forced to agree to your terms. So UK say cannot, okay, Malaysia also say cannot. So whenever you cannot perform, you don't go and ask for more money. you say I very unlikely lah, you don't say 100% I can complete, you say very unlikely I cannot complete on time because of certain facts, and then you let the other party offer you more money, then you got no economic duress lah. Alright. So there are some problems with economic duress and practical benefit. On the one hand, they say there is a practical benefit, so there is consideration mah. But the other hand, they say no, there's economic duress, so there is no consideration. So the law is a bit uncertain about this, is debatable sometimes. So you never know in the court, the judge will take which argument. Okay, depends on the facts. So in the Singapore Court of Appeal, they have hinted that they want to replace consideration with economic duress, promissory estoppel, and unconscionability for contract modification. So in US, they don't need consideration when you modify a contract. But yeah, Malaysia, I think, still follows UK. And lastly is even if you fail in all these, there is one more recourse in equity, which is promissory estoppel. So if the other side made a promise and you rely on it to your detriment, the other side is stopped from changing his promise. Okay, even though he didn't, there's no consideration that you give. Right? But this can only be used as a shield. So you are the contractor, you cannot sue for more money. You cannot sue for him to pay you, because that is considered a sword. Because this is the rules of equity. You cannot sue. But if you people sue you, then you can apply promissory estoppel. So in conclusion, we always want to be clear whenever we enter into contracts lah. Okay, don't care about whether we have the terms, what are the terms of the contract yet. But yeah, like when I send my when I enter into agreements for services, we want to be sure lah, like when the company pays money, pays deposit, okay, we want to know whether there's a contract or not, or can you get back your deposit. Right? When you send, let's say you want to buy a car, a lot of times the deposit is refundable lah. Okay? So it all, it's quite practical actually. Okay, this is just the theory, but when you apply to the facts, it's very important. Okay, thank you, bye.